have submitted a green sheet. We're asking for an adjournment. Ms. Dunn has a assessment at the Sacred Heart treatment facility tomorrow. I do have verification here. It's the Sacred Heart program that's up in Richmond, which I think is up in northern Macomb County. It looks like it's their model is a 12-step type approach. It is inpatient.
On an amphetamine of some type.
Excuse me, Judge?
On an amphetamine of some type.
You mean prescribed?
Have
Yeah, I don't believe so, Judge.
this should be clarified. So why is she testing positive for amphetamines?
Your Honor, I believe this was the initial test after arraignment. We are asking.
This might sound like a simple delay request, but listen carefully. When a judge asks about drug use and the answer is, "I'm not sure," that's a problem. In court, uncertainty can cost you your freedom.
For an adjournment.
Will she test clean today?
I'm sorry?
Will she test clean today?
I'm not sure, to be honest.
You're not sure?
I haven't used, I know that, but I don't know.
I think she's. It's my understanding she doesn't know the half-life of it, Your Honor. I believe her initial test was.
That was she saying?
Or the 5th. Well, she
When's
said,
the last time did you use?
It was a couple days ago. That's why I'm seeking in-house treatment. Your Honor.
Your Honor, I do have documentation.
There it is, the moment everything shifts. Admitting drug use just days ago weakens the entire defense. Treatment tomorrow sounds good, but the judge is focused on today's reality.
Here that she is seeking to address the root cause of any of this behavior. Like I said, she has an intake tomorrow. I can. It's at 1 p.m. That's in Richmond. She is here. This issue today. I can offer it to the.
She tests on the 6th. She's positive on the 6th. I'm now here on the 12th, and she's using by the 10th. I have no guarantee that she's going to make it even to treatment.
Yeah, I promise you I will have my 4 kids with me, sir, Your Honor.
You know, she has a lot at stake.
I understand that, including her life.
Yeah, sure.
I'll adjourn the probable cause conference March 19, 2026, 9 a.m. This time the defendant's bond is revoked. Defendant remanded.
Thank you, Your Honor.
Laquita Thompson.
People.
And Assistant Public Defender Nick Bukovich on behalf of Ms. Thompson, who's now approaching. Can you please state your name for the record?
Laquita Thompson.
What are we doing? You're seeking an adjournment?
Yes, I am seeking an adjournment, Your Honor. And I'm prepared to address the corrections report.
Pardon?
I said there was a note for community corrections reports. I'm prepared to address that.
And on February 22nd, she blew numbers. We're at her 3 blows, then she took an EEG the next day. It came back.
Yes, Your Honor. In addressing the alleged violation, my client does indicate he does admit to drinking on that 22nd date. It was unfortunately she did lose a friend of 24 years, someone she worked for and has known for a very long time. And unfortunately, as part of the grieving process, she does admit she did have a moment of weakness and there was a mistake and she did drink. She is working very hard on maintaining the good strides she has made in her life. She currently works 2 jobs, One where she works approximately 12-hour shifts on her feet at a manufacturing factory. She has done community service. She attends AA meetings. I actually do have AA sign-in sheet that I can provide to the court and the prosecution. She attends them both in person when she's able to, and on Zoom when her work schedule does not allow her to make in-person dates. I do want to note, prior to being placed on the prior to being placed on the sober link, she did have no violations on the Scram tether. She had to be placed on the sober link due to issues with her ankle, and that was why at the previous PCC date you allowed her to switch over to the sober link. I do note I do understand there are several late tests. However, I do want to note several of those tests she did test within 10 minutes after the time frame occurred. I think 7 of those total. And for all of those late tests, she was negative. She does, as I indicated, work on a manufacturing line. So sometimes there are moments where she cannot physically step away from that line due to the ongoing working process, as it would be obviously a process issue for the process of work, but also for safety down the line. She has indicated that she has reached out to her supervising agent to discuss these matters when she does have a late test. She is actually working on obtaining a house and was actually supposed to assign on that house today. She is doing a lot of work to improve her life, continue doing what she must. And I think it is clear that she is attempting to do with everything within her power to comply with the bond conditions. So at this time, Your Honor, I would be requesting that she have a second chance and that her PR bond be maintained.
Any response to the people?
My concern, Your Honor, is that we kind of was on a tether and we agreed to change her to a sober link. Now she has these issues.
Yep.
And it was right about the graciousness of the court to modify those conditions. So, here as I can see, there's an option.
What's that option? Lock me up.
I will adjourn the probable cause conference to
I have-
March 19, 2026, 9 a.m. Defendants bond at this time, having it
Oh my
violate
God,
both defendants remanded.
I have 2 jobs. I have 2 jobs. Oh my God.
2 different defendants, same final result. One asked for time, the other showed effort, but both violated conditions. And in court, compliance isn't optional. So what do you think? Should effort matter more, or are rules everything?